Hi everybody, this is CA Puneet Goyal, an indirect tax professional in India. Today I am going to discuss with you how services can be categorized in Finance Act 1994. Here services can be categorized in following manner. One is negative list approach. Services can be categorized in negative list approach, and second one is services can be categorized in declared services. Third category is mega exemption notification. These are those services which are given in mega exemption notification. Fourth one is services which are given in abatement notification. Fifth one is services which are given in reverse charge mechanism and joint charge mechanism. Next one is services given in Rule 6 of Service Tax Rules 1994, in respect of which special rate is given. Next one is services which are given in Rule 2 of Service Tax Determination of Value Rules 2006. Here services has been categorized in 7 ways based on the treatment and valuation given in various rules and notifications. Now we are going to discuss these services one by one. First one is negative list. Services which are given in negative list, that is, these are the services which are given under Service Tax Act itself, that is in section 66D. This section covered those services which are purely not covered by the service tax provisions and not taxable at all. Now we are talking about second category, that is services which are given in section 66E, and these are called declared services. Under this category, those services has been categorized in respect of which there are confusion that whether service tax would be paid or sale tax would be paid. Now government has, in order to remove this confusion, mentioned list of services which would be considered as declared services, and now the confusion is removed whether it is taxable under Service Tax Act or not. If it is given in declared services, in that case it would be taxed as per the provisions of service tax rules. Third category is services which are given in mega exemption notification. These are those services which are taxable, but governments think that these should not be taxed and some exemptions would be given in respect of these services. So notification number 25/2012 contained the list of services which would be exempt subject to the condition given in that particular notification. And fourth one is services in respect of which abatement is given. There are some services where government do not want to pay service tax on full value, or services in which there are element of material also. So in this notifications, government has given some abatement in respect of material element or in respect of those services in respect of which service government want to give some exemption in value of services itself. Next category is that is fifth one, that is services which are given under reverse charge mechanism, and these are given under notification number 30/2012. These are those services in respect of which service receiver is required to pay service tax instead of service provider. Generally, as per Service Tax Act, service provider is required to collect the service tax and deposit to the government. But in respect of services which are given in notification number 30, service tax is required to be paid by service receiver itself, or in some cases service receiver or service provider both. These are called joint charge services. And percentage of service tax payable by the service receiver and service provider is given in this notification. Now we are proceeding to next categorization of services, that is sixth one, that is services in respect of which service tax is payable as per special rate given under Rule 6 of Service Tax Rules 1994. Here there are some services in respect of which service tax is not required to be paid with full rate of service tax. For example, services provided by insurance company, services provided by air ticket agent, etc. In respect of these services, government was not to pay service tax with full rate, and abatement is required to be provided. And this abatement has been provided through Rule 6 of Service Tax Rules 1994. And last category which can be categorized is services in respect of which value is given in Rule 2 of Service Tax Determination of Value Rules 2006. Here there are services, Rule 2 contains those services in respect of which government has decided on which value service tax is required to be paid. So through this presentation, I want to convey the message that before giving any consultation or analyzing service taxability on value of service under Service Tax Act, one should first of all go through how the services can be categorized and in which category the service falls, so that accordingly correct calculation and valuation of service can be done. I hope the given presentation is useful for you, and your feedback in respect of same would be highly appreciated. You may also note down our blog. You may give your suggestions and request on it. We will consider it and revert to you. Our blog is srpgc.blogspot.com. Thank you very much. I hope this is useful for you.